Crime is wickedness. Crime is greed. Crime destroys families. Crime divides nations.
Which I then move on to give reasons why the prosecution is not opposing bail.
Okay.
The applicant handed herself over to law enforcement through her attorney. It is interesting, Your Worship, the last point that is not part of the affidavit, I had it noted as part of the reasons why we are not opposing bail. So in essence, I am saying I have no objection to the address from the bar regarding this aspect. I've noted here that the other reason we are not opposing bail is the seniority in terms of age of the applicant. And it is a fact of life that as you grow older, you tend to have health issues. So we accept the issue of the hypertension and the medication alluded to. The address of the applicant was confirmed. As Your Worship is aware from the affidavit, a search and seizure was conducted at her residence on the 19th of March in the presence of her husband. So the address is verified. I wish to address this way, Your Worship. I'm basing this on Section 60, the considerations and case law, the famous case of Dlamini et al. Although there is always a flight risk of a person who is released on bail absconding, what the law concerns itself with is the likelihood of that risk materializing. We as the prosecution cannot say that the applicant, Mrs. Mapisa Nqakula, is not a flight risk simply because the decision to abscond or not is solely on her. But what I can tell this court is that as the prosecution, we have no reason to believe that there is a risk of the likelihood of her absconding, and therefore I ask the court to accept that she is not a flight risk. Those are the reasons.
Thank you, sir.
The instructing attorney called me yesterday and he asked how much bail are we looking at. He proposed 50,000 rand. I said I will ask for 100,000 rand. Obviously this court is not bound by either amount. So the reason I ask for 100,000 rand is informed. If one looks at the amount of the schedule, it's 4,550,000 rand. However, that amount relates to the gratifications that were allegedly asked for by the applicant. In terms of our law, that is sufficient. Even if you do not give the gratifications, if you ask for it, that's criminal. However, out of the 4,550,000 rand, a total of 2,150,000 rand was actually given to the applicant by the witness. Based on that amount, 2,150,000 rand, I submit that 100,000 rand would not be unreasonable and disproportionate to the magnitude of the offense. I add, Your Worship, that count 13 is clear. We are charging the applicant with laundering of that money that was received. We know what that money was used for, hence the money laundering charge. I submit that 100,000 rand is reasonable. Thank you.
Thank you. Advocate?
Your Worship, I'm timid to indicate this, but I've just taken an instruction from my attorney That is not how he remembers the telephone call went relating to the 100,000 rand. Now, I'm not going to be long, Your Worship. The principle about bail is, what can you afford? I think for any South African in the economic climate as it is at the moment, 100,000 rand is unnecessarily high. And what the ground principles, as I understand it, is there's no linear line between it's a lot of money, therefore the bail should be high. And the Worship considers all the issues in my client's affidavit, her assets, her liabilities, the fact that she's now a pensioner, it's common cause, her family connections, and all those things, all the personal circumstances cited in her affidavit, along with the quantum, which is now just an allegation. It's not proof. And insofar as my learned friend said, submits to Your Worship that it is proved, it is, we haven't had the trial yet. So in my respectful submission, taking all of those issues into account, the criterion that applies to Your Worship's thinking in my respectful submission is my client a flight risk? Now, I've already commented on my praise for the state in alleging that my client is not a flight risk. They've satisfied themselves from their investigations and from the admissions they've made that my client is not a flight risk. So in my respectful submission, the mere submission, it's a lot of money, therefore she's a flight risk, now contradicts what the state have alleged previously. So it's an issue of what my client can afford. It's an issue on that we were given the expectation that that would be the amount. But those are relatively small weights when Your Worship looks at the issue of the conspectus of facts, all the facts, which point to the fact that my client is not a flight risk. And if those are actually common cause, therefore the amount of bail need not be high because all of them function as an anchor of my client in Your Worship's jurisdiction. So I would accordingly submit that 50,000 rand is ample to satisfy the state that my client.
Advocate, can you also address the court, because the Act is very clear that the court must look at the ability and the affordability. Can you elaborate on that with respect to the amount of bail?
Insofar as that is concerned, my client is now a pensioner. That puts her, in my respectful submission, into a special category of person now. My client is very senior. Her earning capacity has now decreased in my humble submission. And those issues would influence Your Worship's decision as to whether the amount is appropriate or not, as it pleases the court.
Thank you. In considering the further addresses in terms of Section 2, capital B, sub A of the Bail Act, when the court needs to consider the quantum, it is so that all factors need to be considered. Not only the amount that is alleged, that is in this matter, as stated by the state in the annexes to the charge sheet, but all factors that I've already mentioned in the court, and a balance need to be struck. And again, affordability is one of the questions that the court needs to consider. It is clear that the applicant has resigned. It is not disputed, it's common cause. What her financial position is was not in cents and rands set out to the court, but The court has asked Mr. Kerr Phillips to address the court on affordability, and they have answered that question. The court is satisfied, as I've stated, that the applicant is not a flight risk, that investigation has been done, and that further accused persons might be added to this matter. So the court is satisfied that the amount initially suggested of 50,000 rand is adequate in this matter. The following conditions is, however, imposed, and that is that the applicant must hand over her passport as requested by the state on or before Monday the 8th of April, on or before 1600 hours at the office of the investigating officer in this matter. And secondly, that the applicant does not have any contact directly or indirectly with any of the witnesses of the state. The matter is then postponed to the 4th of June, back to this court, Court 16. Ma'am, you are warned to be here at 8:30 on that day, should you pay your bail. I'm sure your attorney will explain to you, should anything happen and you cannot be here for any reason, contact your lawyers of record, make arrangements with them, because if we do not hear from you and we do not know where you are, the state can argue and request a warrant of arrest to be authorized and the bail forfeited to the state. Do you understand that, ma'am? Thank you. Court is adjourned.
Who's Mama?